The courtroom feels unusually quiet. The kind of quiet that comes right before something complicated begins. Lawyers shuffle thick files across wooden tables. A few whispered conversations fade as the judges take their seats. Another day of the presidential election tribunal is about to unfold, and everyone in the room seems to sense that today might not go smoothly. There will be sharp objections, tense exchanges, and evidence that leaves more than a few people shifting in their chairs. So what exactly happened when the proceedings finally began? As the session for June 15th begins, the courtroom settles into that familiar rhythm. Papers sliding across desks, lawyers adjusting their robes, the quiet murmur of conversation fading as the judges take their seats. Everyone knows the next witness matters. The Labour Party's legal team has come prepared, and this time they are bringing forward someone they believe can help explain the numbers behind the election. Not long after the court settles, the Labour Party introduces a subpoenaed witness, a professor of mathematics, a man whose work they say centers on analyzing data, exactly the kind of expertise they want the court to hear. He walks to the witness box, takes the oath, and sits down. The room grows attentive. When the questioning begins, the Labour Party counsel keeps it simple at first. "Tell the court what you do," the professor answers calmly. He explains that he is a professor of mathematics at a university in Anambra State. His voice is steady, the tone of someone used to explaining complex ideas in classrooms and lecture halls. But the moment doesn't last long. Before the examination can move any further, a lawyer representing the Electoral Commission rises to his feet. There is a noticeable edge in his voice. He tells the court that something is wrong with the way the witness has been presented. According to him, the witness statement, along with several appendices, was only served on their team that very morning, just minutes before the session began. He explains that he and his colleagues barely had time to glance at the documents, let alone study them properly. From what he can already see, the statement appears to include 6 or 7 appendices. That alone suggests the testimony could involve detailed analysis, and that he argues puts them at a disadvantage. Standing before the bench, he tells the judge that proceeding under those circumstances would be unfair. Legal proceedings, he says, should not be about surprising the other side. There should be cooperation between counsel. Documents like these should have been served earlier, so everyone has enough time to review them carefully. His request is straightforward. If the Labour Party wants to proceed with this witness, then the witness should step down for now. The opposing lawyers need time to examine the statement and the appendices before the testimony continues. As he finishes, the tension in the courtroom rises just a little. It's the kind of moment that can change the pace of an entire hearing. Soon after, another lawyer, this time representing one of the respondents, stands to speak. He signals that he agrees with the concern raised. The documents need to be studied first. The witness, he suggests, should step down briefly so the lawyers can review the material. But the frustration is already visible. From their perspective, this is not a small issue. A technical witness, especially a mathematician analyzing election data, is likely to rely heavily on documents. If those documents are complicated, and the number of appendices suggests they might be, then understanding them quickly is almost impossible. The request to pause the proceedings hangs in the air. Across the room, the Labour Party team waits for the court's direction. The witness remains seated in the box, quiet, while the lawyers argue over timing and fairness. And just like that, only minutes into the day's hearing, the tribunal has already run into its first clash. The objection doesn't end the discussion. In fact, it opens the door to something bigger. Another lawyer rises, this time representing bolaahmedtinubu. He signals that he agrees with the concern raised by the Electoral Commission's counsel. The documents clearly need to be reviewed first, but instead of asking for a long delay, he suggests something shorter. Perhaps the witness could simply step down for a few minutes, just enough time for the lawyers to look through the statement and its appendices. But before that idea can settle in the room, the lawyer for the Electoral Commission reacts sharply. He interrupts almost immediately, clearly dissatisfied with the suggestion. Minutes, he pushes back. That isn't what he asked for, and that certainly isn't what the rules require. His position is firm. If this witness is going to testify as an expert, especially someone presenting technical analysis, then the opposing side is entitled to proper time to study the materials. Not a quick glance, not a rushed reading while the witness waits. He insists the rule is clear. They need 48 hours. That number hangs in the courtroom for a moment. At that point, the presiding judge leans forward slightly, listening carefully. Then he asks a simple question. Which rule says that? The courtroom grows quiet again as the lawyer explains. According to him, the tribunal schedule requires 48 hours for expert reports. He adds that the federal high court rules contain similar provisions. In his view, the legal framework is already there, it simply needs to be applied. But the conversation is no longer moving in a straight line. The lawyer for Tinubu speaks again, adjusting his earlier position. After a brief exchange with colleagues, he offers what sounds like a middle ground. If the court wishes, the witness can continue with the examination today. However, there will be no cross-examination right now. Instead, their team would study the documents first and return to question the witness later. That way, they avoid being ambushed by technical material they have barely seen. Soon, the lawyer for the APC signals that his team shares a similar position. They too were only served the documents shortly before the hearing began. If the witness proceeds, they would reserve the right to cross-examine at a later time after properly reviewing everything. In other words, the courtroom begins drifting toward a compromise. Let the testimony move forward, but postpone the real challenge, the cross-examination, until the lawyers have had time to study the evidence. It's a subtle maneuver, but an important one. Allowing the witness to continue keeps the day's proceedings moving. At the same time, delaying cross-examination protects the respondents from being forced into questioning a technical expert without preparation. Across the room, the Labor Party team listens carefully. The witness remains in the box, waiting quietly, while the lawyers map out the rules of engagement. And slowly, the courtroom edges toward a solution that lets the hearing continue without closing the door on a much tougher round of questioning later. With the dispute about timing temporarily settled, the examination moves forward. The Labor Party counsel returns to the witness with a simple step that usually passes without drama. He shows the professor his written statement. "Do you recognize this document?" The witness looks at it and answers calmly. "Yes," he says. It is his statement. It carries his signature and the words he prepared for the court. The next step should be straightforward. The lawyer asks whether the witness adopts the statement as his evidence before the tribunal. But before he can give that final confirmation, the professor raises a hand slightly and speaks up. There is something he wants to clarify first. He points the court to a specific part of the document, page 5. According to him, there is a small issue in one of the tables included in the statement. A line that should refer to Benue State mistakenly mentions Rivers State instead. It is, as he describes it, a simple correction. But the moment the explanation begins, the presiding judge interrupts. Once a statement has been adopted, the judge says corrections cannot be made inside it. Court documents are meant to stand as they are. For a brief second, it seems like the discussion will end there. Except the Labor Party counsel immediately steps in. He respectfully points out that the witness has not yet adopted the statement. The clarification is being raised before that final step. And in his view, the witness should be allowed to point out a minor mistake in the document before confirming it as his evidence. Across the courtroom, the lawyers representing the respondents are already preparing their response. The lawyer for the Electoral Commission rises again. From his perspective, the proposed correction is not as harmless as it sounds. Changing the name of a state inside a table is not something trivial. In fact, he argues that such a change is too substantial to be made casually in the courtroom. If the witness believes the document contains errors, then the proper approach is simple. Withdraw the statement. Correct it fully outside the courtroom, and return another day with the revised version. Soon the lawyer for the APC signals that his team shares the same concern. They align themselves with the position already stated. In their view, this is not the kind of alteration that should happen on the spot. Meanwhile, the Labor Party counsel pushes back. He explains again that the correction involves just one line in a table. The entire surrounding page already refers to Benue State. The mention of Rivers, he says, is clearly a typographical slip. Nothing more. He reminds the court that similar clarifications have been allowed before adoption of statements during previous proceedings. In other words, this would not be a new or unusual step. For a moment, the discussion circles in place. The judge listens carefully, weighing the arguments from both sides. On one hand, the court must protect the integrity of its documents. On the other, the witness is simply trying to clarify what appears to be a small mistake before formally adopting the statement. Eventually, the resistance begins to soften. The Electoral Commission's lawyer, having made his objection clear, steps back slightly and tells the court he will leave the final decision to the judge's discretion. The APC lawyer does the same. Now all eyes return to the bench. After a brief pause, the presiding judge gives his ruling. The witness may proceed with the clarification. Relief spreads quietly across the Labour Party table. The professor explains once more that the table should refer to Benue State, not Rivers State, and that the surrounding documents already make that clear. With the correction acknowledged, the process finally returns to where it paused. The lawyer repeats the question. Do you adopt this witness statement as your evidence before the tribunal? This time the professor answers without interruption. Yes, he says. And just like that, the statement is formally adopted, allowing the examination to continue. With the witness statement finally adopted, the examination begins to move deeper into the substance of the testimony. The Labour Party counsel turns to the professor again, guiding him toward the heart of the analysis he has prepared. At one point, the lawyer asks about a figure mentioned in the statement, 18,088 polling unit result sheets. The number immediately catches attention. It sounds massive, and the judge wants to know exactly where this figure appears in the documents before the court. The lawyer points to the relevant paragraphs in the statement and begins explaining that the materials supporting the witness's analysis have been compiled carefully. But before continuing further, he makes a remark that shifts the energy in the room. He says that his team has gone the extra mile to prepare copies of the supporting documents, not just for the court, but for the lawyers on the other side as well. And with that, the distribution begins. Assistants start carrying the materials across the courtroom. Thick bundles of documents move from one table to another. One set goes to the lawyers representing the Electoral Commission, another to the legal team for the president's side. At first, people simply watch the process quietly. But as the stacks continue to appear, something becomes clear. These are not small folders. These are enormous volumes of documents. Soon, murmurs begin to ripple across the courtroom. Lawyers glance at one another. A few heads tilt forward as they try to gauge just how large the evidence really is. The piles grow higher on the tables of the respondents' legal teams. What they are looking at is a compilation of thousands of polling unit result sheets, documents the witness says were analyzed as part of the data review. Many of them, according to the claim being presented, contain blurred or illegible entries. The physical size of the evidence is impossible to ignore. Some observers in the courtroom audibly gasp as the final stacks are placed down. Even the judges appear momentarily surprised, studying the thick volumes now sitting before them. Across the room, the lawyers for the respondents do not look particularly amused. The Labour Party counsel, meanwhile, allows a small hint of sarcasm into his voice. He notes that his team has been generous enough to provide copies so that their learned friends on the other side will not need to apply to the court for permission to make their own. The presiding judge hears the comment and responds with a mild grin. He remarks that he can see how generous the counsel has been, very generous indeed, with such heavy loads of documents. The courtroom chuckles lightly at the exchange, but the tension underneath the humor is obvious. For the respondents, these documents represent something else entirely, an enormous body of evidence that now needs to be reviewed and challenged. Almost on cue, an objection rings out from the respondent's side. It arrives quickly and loudly, though the exact reason behind it is not immediately clear. Moments later, another lawyer joins in, clearly still processing what has just landed on their table. He remarks that when he first saw the boxes brought into court earlier that morning, he thought they were something else entirely. Perhaps gifts or items for a celebration. The implication draws a few more smiles around the room. But the APC counsel quickly pushes back, raising an objection to the entire development and stating that the reasons for the objection will be presented later during final arguments. Despite the protests, the process continues. The court examines the materials and confirms that the documents meet the requirements for admission at this stage of the proceedings. Then comes the moment that quietly shifts the hearing again. The presiding judge announces that the volumes will be admitted into evidence. Just like that, the towering stacks of documents are officially marked as exhibits before the tribunal. For the Labour Party team, it is a significant step. For the respondents, it marks the beginning of an enormous task, studying and responding to thousands of pages now sitting in front of them. The courtroom settles again, though the atmosphere feels different now. The earlier curiosity has turned into something heavier, because everyone present understands the same thing. Those massive volumes are not just stacks of paper. They are now part of the official record of the case, and whatever story they contain will eventually have to be examined in full. Even after the shock of those massive documents settles, the hearing is far from slowing down. If anything, the tension inside the courtroom begins to build again. The Labour Party counsel turns back toward the witness, continuing the examination where it left off. The focus returns to the analysis the professor carried out and the polling unit result sheets he referenced earlier. But before the witness can fully respond to the next question, another interruption arrives. One of the lawyers representing the respondents rises again, this time sounding visibly concerned about how long the testimony is taking. He addresses the court directly, pointing out that the witness has already spent more than 2 hours on the stand. From his perspective, this is becoming excessive. He asks the court to consider how much longer the witness intends to remain there. If the proceedings continue at this pace, he warns the entire day could be consumed by a single witness. The concern isn't just about time. It's also about the growing mountain of evidence being introduced alongside the testimony. Across the room, the Labour Party counsel responds calmly. He reminds the court that his team is not the one slowing things down. Many of the interruptions he suggests have come from repeated objections by the respondents. And besides, he adds, part of the reason for carefully laying out the evidence now is to justify the very request the opposing lawyers made earlier. If they need 48 hours to study the material before cross-examining the witness, then the court must first see the full scope of what that material actually is. At that point, the presiding judge steps in. His tone is measured, but the message is clear. He asks the Labour Party counsel a direct question about the documents being tendered. Are these result sheets certified by the Electoral Commission? The lawyer confirms that they are. Still, the judge reminds him that time is moving quickly. He encourages the counsel to begin rounding up this part of the examination. The response from the Labour Party side is respectful but firm. The lawyer tells the court that he is grateful for the opportunity and proceeds to formally request that the polling unit results, 18,088 of them, be admitted into evidence. The reaction from the respondents is immediate. Voices rise again from multiple directions, announcing objections almost in chorus. Yet while those objections are being voiced, something else is happening at the same time. Members of the Labour Party team continue distributing additional copies of the documents to the opposing lawyers. By the time the objections settle, the evidence is already sitting on the tables. The judge reviews the request, and despite the protests, decides to admit the materials into evidence. One after another, the documents are marked and added to the official record of the tribunal. The tension in the courtroom thickens once more. Because every new document being admitted means more evidence to examine, more arguments to prepare, and more questions waiting ahead. And yet the hearing continues moving forward. As the professor's testimony winds down, the Labour Party team signals that they have another witness ready. The courtroom shifts again as a new figure is called forward, this time a journalist from Arise News. He takes the stand, confirms his identity, and acknowledges that he was subpoenaed to appear before the tribunal. The process moves quickly. The lawyer guiding the examination asks if he recognizes the written statement submitted to the court. Yes, the witness replies. It is his statement. He confirms that the words in the document are his and that he stands by them. But the real focus of his testimony isn't the paper in front of him. It's something much smaller. A flash drive. The lawyer asks the witness whether he mentioned this device in several paragraphs of his statement. The witness confirms that he did. Then comes the next question. Do you have the flash drive with you? Again, the answer is yes. The Labour Party counsel immediately moves to tender the flash drive as evidence before the court. He explains that it contains a short video recording about 3 minutes long, and that copies will be made available to the lawyers on the other side. Almost on cue, objections begin rising again from the respondents' tables. The exact arguments will be reserved for later, but the resistance is clear. Still, the court considers the request. After a brief moment, the presiding judge allows the flash drive to be admitted into evidence. The courtroom grows noticeably quiet as arrangements are made to play the video. Soon the screen lights up and the clip begins. The footage shows the chairman of the Electoral Commission speaking during an event at Chatham House in the United Kingdom. In the recording, he discusses details about voter registration and other information connected to the election process. For a few minutes, the courtroom simply watches. No arguments, no interruptions, just the video playing in full view of the judges, the lawyers, and everyone observing the proceedings. When the clip ends, the moment hangs in the air briefly before the tribunal prepares to move on. By the time the session finally pauses, the courtroom has already seen a day filled with sharp objections, tense legal arguments, and evidence that left more than a few people surprised. Massive stacks of documents, a mathematician's analysis, even a video played right there in open court. And yet this is only one step in a much longer case. The next hearing could bring even more twists. If you want to follow how it all unfolds, stay connected and keep watching for the next update.